In the previous section, we explored the various types of deeds used in Arizona real estate transactions and learned how each provides a different level of protection for the parties involved. Whether transferring ownership through a general warranty deed, conveying limited rights through a quitclaim deed, or designating future beneficiaries through a beneficiary deed, every deed, regardless of its type, must meet certain legal requirements to be valid and enforceable. These essential elements ensure that the conveyance is properly executed, legally recognized, and capable of being recorded in the public record. Under ARS, paragraph 33-401 through paragraph 33-411, Arizona law sets forth the criteria for a deed to be valid. A deed is not just a written document, it is a legal instrument that, when properly executed and delivered, transfers ownership or an interest in real property from the grantor, seller, to the grantee, buyer. To be valid, a deed must contain specific components that establish its authenticity, intent, and enforceability. 1. Competent parties. For a deed to be valid, both the grantor and grantee must be legally competent. This means they must be of sound mind, of legal age, and have the legal authority to transfer or receive property. A corporation, trust, or estate must act through an authorized representative, such as a corporate officer, trustee, or personal representative. For example, if a property is owned by a living trust, the trustee signs the deed on behalf of the trust. If a property is owned by a deceased person's estate, only the court-appointed personal representative, as authorized under ARS, paragraph 14-3701 et seq., may sign the deed. 2. Words of conveyance, granting clause. A deed must contain clear language, expressing the intent to convey ownership. This is known as the granting clause, typically using words such as grant, bargain, sell, or convey. These words demonstrate the grantor's intent to transfer title and distinguish a deed from other written documents. For instance, the phrase, "I hereby grant and convey to John Smith and his heirs," is sufficient to express intent. Without this clause, a court may determine that no valid conveyance occurred, even if the parties intended one. 3. Property description. A valid deed must include a legally sufficient description of the property being conveyed. The description must be specific enough to identify the property without ambiguity. In Arizona, property is typically described by lot and block number, meets and bounds, or government rectangular survey system. A street address alone is not adequate for legal purposes, although it may be included for reference. For example, Lot 12, Block 4, Sunridge Subdivision, according to the plat recorded in Book 23, page 9, of the Maricopa County Recorder's Office, would constitute a sufficient legal description. 4. Consideration. Although a deed does not require monetary consideration to be valid, it must recite that something of value was exchanged. The consideration clause may reference an actual amount, such as for the sum of $500,000, or a nominal amount, for $10, and other valuable consideration. The purpose of this clause is to show that the transfer was intentional and not a gift made under duress or mistake. In Arizona, even deeds transferring property as gifts, such as from parent to child, typically include nominal consideration to satisfy this legal formality. 5. Signature of the grantor. The deed must be signed by the grantor, the person conveying the property. The grantee's signature is not required. When property is owned jointly, all owners must sign to convey their interests. If the property is community property, both spouses must sign the deed under ARS, paragraph 25-14C, which requires mutual consent for transferring or encumbering community real estate. 6. Delivery and acceptance. A deed must be delivered by the grantor and accepted by the grantee to become effective. Delivery means the grantor intends the deed to take immediate effect, not at some future time. Acceptance can be express, such as signing a receipt, or implied, such as taking possession or recording the deed. Once delivered and accepted, ownership transfers immediately. For instance, if a seller signs a deed but keeps it locked in a desk drawer, the transfer has not occurred because the deed has not been delivered. However, if the deed is handed to the buyer or recorded with their knowledge, delivery is presumed. 7. Acknowledgement. To be recorded and enforceable against third parties, the deed must be acknowledged before a notary public or other authorized official. The notary confirms that the grantor's signature is genuine and that the grantor signed the deed voluntarily. Without acknowledgement, the deed is still valid between the parties but cannot be recorded, leaving the transaction vulnerable to later disputes. 8. Recording. Although recording is not a requirement for validity between the grantor and grantee, it is essential for protecting ownership rights against third parties. Under ARS, paragraph 33-411, recording provides constructive notice to the public that ownership has changed. Failure to record could allow a later bona fide purchaser to claim superior rights if they record first. For example, if a seller conveys the same property to two different buyers and only one records the deed, the first to record generally holds legal title. This underscores the importance of immediate recording after delivery. Case example: Main Eye Lydiard Partnership v. Venture Capital Construction and Development Corp., 2001. In this Arizona case, the court reaffirmed that for a deed to be valid, it must contain clear granting language, an accurate property description, and evidence of delivery and acceptance. The case also emphasized that failure to record a deed can expose a grantee to risk from later claims by third parties. Discussion: Why is delivery and acceptance necessary for a deed to be valid? Answer: Because delivery and acceptance demonstrate the intent of both parties to transfer ownership immediately, completing the conveyance process. Why is acknowledgement important, even though it is not required for the deed to be valid between the parties? Answer: Because acknowledgement allows the deed to be recorded, providing public notice and protecting the grantee's ownership rights against third parties. What might happen if a property deed is not recorded after delivery? Answer: A subsequent purchaser who records their deed first could acquire superior title, even if they bought the property later. Review summary. To create a valid deed in Arizona, specific elements must be present: competent parties, words of conveyance, a legally sufficient property description, consideration, the grantor's signature, delivery and acceptance, acknowledgement before a notary, and ultimately, recording. These elements are outlined in ARS, paragraph 33-401 through paragraph 33 CGAR 411, and are essential to ensure that property transfers are legally binding and properly documented. Without them, the deed may be void or unenforceable, leading to disputes or title defects. As Arizona case law, such as Main Eye Lydiard Partnership versus Venture Capital Construction confirms, a valid and properly recorded deed provides security and clarity of ownership, protecting all parties in the transaction.